I spent 38 years mapping what water does underground. I knew where it moved, where it came out, whose land it came from. When I retired, I used every bit of that knowledge to find the right property. A 1,200-acre farm in North Georgia, a productive karst spring discharging 84 gallons per minute. I bought it. I knew exactly what I had. 3 months later, I'm installing a boundary fence when the brush cutter hits something. A 4-inch water main, buried 18 inches deep, running east, straight toward the subdivision next door. I took out my compass and sighted the bearing. 285 degrees, almost due west. I drew the line on my parcel map that evening. It pointed directly at my spring. 54 homes, 14 years of water, no easement, no permit, for 9 years. And the HOA president's opening move? She sent me a letter about the fence. Before we jump into it, let's start from the beginning. Tell me where you're listening from, and hit like and subscribe for more content. Walt had spent 38 years learning what water did underground, where it moved, how fast, through what formation, under what pressure, and where it came out. He had started with the Army Corps of Engineers in 1979 as a junior hydrologist assigned to the Savannah District, a 23-year-old with a geology degree from the University of Georgia, and the specific ambition of a young man who had grown up on a farm in South Georgia, watching his father's irrigation wells decline, and had decided to understand why. The Savannah District had put him on groundwater mapping work in his first year, the kind of foundational survey work that produced the aquifer boundary maps that county planners and water utilities used for decades after the field work was done. The kind of work that required patience and precision, and the willingness to spend days in the field with a hand level and a well-logged notebook, rather than in an office making decisions that felt important. He had been good at it from the beginning. By his 10th year, he had been leading survey teams across the Southeastern District, Georgia, South Carolina, the Florida Panhandle, the limestone karst country of north-central Florida, where the aquifer systems were productive enough to supply cities and fragile enough to collapse under the wrong kind of development pressure. The karst work had been his particular specialty, the dissolutional limestone formations that produce springs and sinkholes and cave systems, and the most productive freshwater aquifers in the eastern United States, formations that behaved in ways that confounded engineers who had learned hydrology on different rock types, and that rewarded the kind of careful, methodical mapping that Walt had been doing since his first year in the Savannah District. He had mapped springs across 5 states. He had documented aquifer productivity in formations that ranged from marginal to extraordinary. He had written the technical reports that told water utilities where to drill, and how deep, and what yield to expect, and what the sustainable extraction rate was before the aquifer's recharge capacity was exceeded. He had testified as an expert witness in 4 groundwater disputes over the course of his career, cases where 2 landowners were arguing about who had the right to a water source that moved underground without respecting property lines, and where Walt's mapping work was the factual foundation on which the legal arguments were built. He had retired in 2017 at 66, the retirement a decision made not because he was done with water, but because the Corps had changed in ways that had made the field work he loved increasingly administrative, the survey teams smaller, the mapping projects funded at levels that required shortcuts he was not willing to make. He had left with a full pension, a filing cabinet of field notebooks, and the specific restlessness of a man whose professional identity was entirely built around work he could no longer do in the form he valued. His wife Eleanor had died in 2019, 2 years into his retirement, a pancreatic cancer that moved faster than any of the oncologists had predicted, the illness from diagnosis to death spanning 11 weeks. Walt had spent the following 2 years in the house they had shared in Augusta, the city house, the small yard, the neighborhood that Eleanor had loved, and that Walt had never fully inhabited in the way she had. He had walked a lot in those 2 years. He had read. He had pulled his field notebooks from the filing cabinet, and had spent evenings reviewing work from 30 years earlier, following the aquifer maps with his finger the way you followed a river on a road map, remembering the field days, the formations, the particular quality of light in the karst country of north-central Georgia, where the limestone came close to the surface, and the springs ran clear and cold, even in August. He had decided to find a farm in the spring of 2021, the decision emerging from the notebooks rather than from any single moment of resolution. He had spent 38 years mapping productive groundwater systems, and he wanted to own one. Not for agricultural production, though a working farm was part of what he had in mind. For the water. For the particular satisfaction of owning land over a productive aquifer in a karst formation, and knowing exactly what was beneath him and why. He had hired a real estate broker who specialized in rural agricultural properties across North Georgia, and had told her, "I'm looking for 500 acres minimum, working farmland preferred, and I want to see the hydrogeological survey data for any property before I make an offer." The broker had said she had never had a client request hydrogeological survey data as a purchase condition. Walt had said, "Now you have." The Caldwell County property had come to his attention in January 2022, a 1,200-acre assemblage of 14 separate parcels that had been held by a Gainesville-based land investment company for 6 years and were being offered as a package. The assemblage included cropland, timber, a creek drainage, 2 stock ponds, a farmhouse in need of renovation, and, on the northeastern section of the largest parcel, a natural spring. Walt had asked the broker to request the county's well and spring records for the property before he drove to see it. The records had arrived by email 2 days later. The county health department's well and spring registry, the entries showing a spring on parcel CW-002-0017, with a discharge measurement of 62 gallons per minute recorded in a 2009 county survey. Walt had looked at that number for a long moment. 62 gallons per minute on a county survey, which typically measured discharge under ordinary conditions, suggested a productive spring in a well-developed aquifer system. The actual discharge rate under optimal conditions could be substantially higher. He had driven to Caldwell County on a Thursday in February. He had walked the property for 2 days before he looked at the farmhouse. The land first, the formations, the drainage patterns, the vegetation indicators that told a trained hydrologist as much about the subsurface water system as a well log. He had found the spring on the second morning, a seep line on the northeastern section of parcel CW-002-0017, the vegetation changing from upland hardwood to the moisture-loving species that grew where groundwater was consistently close to the surface, and then the spring itself, a discharge point in a limestone outcrop shelf, the water emerging clear and steady from a fracture in the formation. He had sat beside the spring for 20 minutes. He had watched the discharge, the water emerging from the fracture, flowing across the limestone shelf, gathering in the natural pool that had formed in the rock below the outlet. He had put his hand in the water, cold, significantly colder than the ambient air temperature, which indicated deep aquifer circulation rather than shallow perched water. He had checked the vegetation around the pool, the watercress, the bryophytes on the wet limestone faces, species that required consistent year-round discharge, species that did not grow at intermittent seeps or seasonal springs. He had taken his discharge measurement kit from his field pack, the same kit he had carried for 38 years, the flow measurement equipment worn but functional, and had measured the discharge at the fracture outlet. The measurement had taken 20 minutes, the methodology the same he had used on springs across 5 states. The discharge rate was 84 gallons per minute. He had written it in his field notebook, the same composition notebook format he had used since 1979. The entry dated and timed, the measurement methodology noted, the site location described by GPS coordinates. He had written below the measurement, highly productive karst spring, deep circulation indicated by water temperature differential, year-round discharge strongly indicated by vegetation assemblage. Aquifer system almost certainly extends well beyond parcel boundaries. Recharge zone likely includes upper ridge to the north and northeast. This is an exceptional water source. He had closed the notebook and had looked at the spring for another few minutes. He had then walked back to the farmhouse and had called his broker. He had said, "I want to make an offer, but first I need to commission a full hydrogeological survey of the property. I want the aquifer boundary mapped, the recharge zone identified, the spring discharge characterized across seasonal variation, and a sustainable yield estimate for the system. I need 2 months." His broker had called the sellers. The sellers, who had been sitting on the assemblage for 6 years and had received no serious offers in the previous 2, had agreed to a 60-day due diligence extension. Walt had retained a hydrogeological consulting firm out of Atlanta, a firm he had worked with on core projects in the 1990s, whose principal was a woman named Dr. Sandra Lim, whom Walt had trained in the field in 1992, and who was now one of the most respected karst hydrogeologists in the Southeast. He had told Sandra, "I want a full characterization of the karst system under this property. Aquifer boundary, recharge zone, spring discharge across the seasonal cycle, sustainable yield, and anything the surface geology tells us about the system's depth and extent." Sandra had put a field team on the property for 3 weeks, the standard karst characterization methodology, the dye tracing to map the aquifer's flow paths, the monitoring wells to characterize the water table elevation, the discharge monitoring at the spring to capture the seasonal variation, the geological mapping of the surface limestone exposures. The report had arrived in Walt's email 6 weeks after the fieldwork began. 44 pages, the aquifer boundary maps in the appendix, the discharge characterization table showing the spring's output across the monitoring period. The spring had discharged at a minimum of 79 gallons per minute and a maximum of 94 gallons per minute during the monitoring period. The variation driven by recharge events, the high flows following significant rainfall, the base flow maintaining at 79 gallons per minute even during the driest stretch of the monitoring period. The sustainable yield estimate for residential water supply was 120 connections at standard Georgia residential consumption rates, with significant margin. The recharge zone extended north and northeast of the spring, entirely within the boundaries of the 1,200-acre assemblage. The aquifer system was self-contained within the property for practical purposes. The recharge zone on Walt's land, the discharge point on Walt's land, the system not dependent on any adjacent property's land use for its productivity. Walt had read the report twice. He had called Sandra and had said, "This is an exceptional system." Sandra had said, "It is one of the most productive private karst springs I've characterized in 15 years. The base flow alone is sufficient for a substantial residential water supply. The aquifer is well protected by the overlying limestone. It is not easily contaminated and not easily depleted at reasonable extraction rates. Whoever owns this property owns a serious water resource." Walt had said, "I'm going to own this property." He had closed on the 1,200-acre assemblage on April 14, 2022. 14 parcels, the farmhouse, the cropland, the timber, the creek drainage, the 2 stock ponds, and the spring on parcel CW-002-0017, whose discharge rate Sandra Lim had measured at a minimum of 79 gallons per minute, and which Walt had known from the moment he put his hand in the water on a February morning, was exactly what he had spent 2 years looking for. He had spent the first 3 months on the property getting the farmhouse habitable, the renovation work proceeding in the methodical sequence Walt applied to everything, the critical systems first, the cosmetic work last. He had hired a contractor for the structural and mechanical work, and had done the finish work himself, the evenings on the farmhouse giving him the particular satisfaction of working with his hands on something that would last. He had also been walking the property, the full 1,200 acres, the 14 parcels, the boundaries between them, and the boundaries with adjacent properties. He had walked the western boundary in May, the southern boundary in June, and had begun the eastern boundary fence project in July. The eastern boundary was the longest fence run on the property, 2.3 miles, the fence separating Walt's land from the Clearwater Pines subdivision to the east, a residential development of 54 homes that had been visible from the ridge on Walt's first site visit, and that had been noted in the title work as the eastern neighbor. The existing fence along the eastern boundary was a deteriorated 3-strand barbed wire fence, the posts rotted at the base in several sections, the wire sagging and broken in others. Walt had decided to replace it with a 4-strand high tensile fence, a proper agricultural boundary fence, the posts set in concrete, the wire tensioned and stapled, the corner assemblies engineered to hold the tension across the full run. He had begun the fence installation at the northern end of the eastern boundary in the second week of July, the post setting proceeding from north to south, the tractor-mounted post driver efficient in the limestone underlain soil once he had identified the lines where the rock was deep enough to allow full post depth. He had been working south along the fence line for 11 days when he found the pipe. It had been a Tuesday afternoon, the heat of a Georgia July, the post driver mounted on the tractor, Walt walking the line ahead of the tractor to flag the next post location. He had been working through a section of the boundary where the existing fence was entirely down, the posts rotted out, the wire lying on the ground, the brush having grown up through the fallen wire over what looked like several years. He had been clearing the brush along the fence line with a brush cutter mounted on the tractor's front end, the clearing revealing the ground surface along the boundary. He had seen the pipe as he cleared a section of heavy brush approximately 400 feet south of the boundary's northern end. It had emerged from the ground on Walt's side of the boundary line, a 4-inch diameter PVC pipe, white, running east-west, disappearing into the ground on the subdivision side of the boundary. The pipe had been buried at approximately 18 inches of depth. The burial revealed where the brush cutter had disturbed the soil alongside the fence line, the pipe's top edge visible in the disturbed earth. Walt had stopped the tractor and had gotten off, and had knelt beside the pipe. He had looked at the pipe for a moment, the diameter, the orientation, the burial depth. A 4-inch PVC pipe running east-west under a boundary fence was a utility crossing. The diameter was consistent with a residential water main, too large for a single residential service line, sized for a distribution system serving multiple connections. He had looked west along the pipe's orientation, the direction from which the pipe was running, the direction deeper into his property. The ground was level and vegetated, no surface disturbance visible beyond the fence line clearing, but the pipe's orientation was clear. He had taken his compass from his field pack and had sighted along the pipe's axis. The bearing was 285 degrees, almost due west, aimed at the northeastern section of parcel C, W-002-0017, the spring parcel. He had not made the connection immediately. He had noted the bearing and had made an entry in his field notebook and had continued the fence work for the remainder of the afternoon. It had been that evening, sitting at the farmhouse desk with his parcel map and the field notebook, that he had drawn the bearing line from the boundary crossing point westward across the parcel map, and had seen where it terminated. The bearing pointed directly at the spring. He had sat with the parcel map for a long time. He had then looked at parcel C, W-002-0017 on the map, the spring parcel, the northeastern section of the assemblage, the parcel he had walked in February, and had sat beside the spring and taken the discharge measurement. He had not explored the full parcel in detail since the acquisition. He had walked the spring area, noted the natural pool, taken his measurement, and moved on to the other parcels in the assemblage. He had not identified any structures on the parcel beyond the natural spring features. He had driven to parcel C, W-002-0017, the next morning. He had parked at the parcel's western access track and had walked to the spring. The spring was, as he remembered, the fracture outlet in the limestone shelf, the pool below, the watercress and bryophytes on the wet rock faces. The discharge was running at what his eye estimated as the normal base flow rate. He had looked around the spring area more carefully than he had in February, moving through the vegetation systematically, covering the ground in a grid pattern from the spring outward. He had found the collection cistern 20 feet east of the spring pool, a concrete structure, partially buried, the top hatch accessible from the surface, the inlet pipe from the spring pool running underground to the cistern's intake. The cistern was large. Walt had estimated 10,000 gallons capacity from its external dimensions, a size consistent with a community water supply buffer rather than a private residence system. He had found the pump house 40 feet east of the cistern, a concrete block structure, 8 feet by 10 feet, a standard utility building, padlocked. He had looked through the ventilation louvers on the building's southern face. He had seen instrumentation panels inside, gauges, a control panel, what appeared to be a VFD-controlled pump unit. The equipment was not new, but it was not derelict. It was operational. He had noted the building in his field notebook. He had noted the cistern. He had noted the pipe running from the cistern toward the pump house, and the 4-inch main running east from the pump house in the direction of the boundary crossing he had found the previous afternoon. He had walked back to the farmhouse and had called his property manager, a local man named Terry Birch, who had managed the assemblage for the previous investment company and whom Walt had retained during his transition period. He had said, "Terry, do you have any information about a pump house and collection system on the northeastern parcel? Parcel C, W-002-0017. It looks like a community water supply system." Terry had been quiet for 3 seconds. He had said, "Walt, I think that system serves Clearwater Pines, the subdivision next door. I believe it was installed when the subdivision was built. I assumed it was part of their infrastructure. Walt had said, "The pump house is on my property. The collection cistern is on my property. The spring that feeds it is on my property." Terry had said, "I didn't realize the parcel boundaries. I assumed the system was on their side." Walt had ended the call and had sat at the desk with his parcel map and the survey description for parcel CW-002-0017. He had traced the parcel boundary on the map, the northern line, the eastern line, the southern line, the western line. The pump house was well inside the parcel boundary. The cistern was well inside the parcel boundary. The spring was well inside the parcel boundary. All of it was on his land. He had picked up the phone and had called David Osei. David had answered on the second ring. Walt had said, "David, Walt Greer. I own 1,200 acres in Caldwell County. I found a water supply system on my property, a spring, a collection cistern, and a pump house that appears to be serving the residential subdivision on my eastern boundary. I need you to look at the title chain for the spring parcel and the subdivision's water use authorization." David had said, "Give me the parcel number and the subdivision name." Walt had said, "Parcel CW-002-0017 for the spring parcel. The subdivision is Clearwater Pines. I need to know if there is a recorded water use easement, a utility easement, a water service agreement, anything that authorizes the subdivision's use of the spring and the infrastructure on my land." David had said, "I'll start Monday morning." Walt had said, "There's one more thing. I found a 4-inch water main running from the pump house east under the boundary fence into the subdivision. The main is buried on my property with no surface marking, no easement marker, nothing. I found it while I was setting fence posts." David had been quiet for 2 seconds. He had said, "No one told you about this when you acquired the property." Walt had said, "No." David had said, "I'll have an answer for you by end of week." Walt had ended the call and had looked out the farmhouse window toward the northeastern section of the property, parcel CW-002-0017, the spring, the cistern, the pump house, the 4-inch main running east under the fence into a subdivision of 54 homes, whose residents had been drawing water from his land since 2008 without his knowledge, and, he was already certain, without any legal basis for doing so. The spring discharged at 84 gallons per minute. It had been discharging into someone else's pipes for 14 years. Walt was going to find out exactly what legal foundation that arrangement rested on. He was already confident the answer was none. David had pulled the Caldwell County deed index on Monday morning at 7:45. His standard start time, the Atlanta office quiet at that hour, the county's online record system loading on his second monitor, while he reviewed his notes from the Friday call with Walt on his first. He had a methodology for title investigations and water rights disputes that he had developed over 22 years of Georgia water law practice, a sequence that moved from the current ownership backward through the chain of title, then sideways into the permitting records, then forward again into any easement or agreement instruments that might have been recorded against adjacent parcels. The sequence was designed to catch the instruments that title examiners missed because they searched only the subject parcel and not the adjacent ones. He had started with parcel CW-002-0017, the spring parcel, Walt's parcel, the current ownership confirmed in Walt's name from the 2022 acquisition deed he had already reviewed in the county's online index. The chain of title had unfolded backward from Walt's 2022 deed in 5 steps. Step 1. Walt's acquisition. The deed recorded April 14, 2022, conveying a 14-parcel assemblage including CW-002-0017 from Caldwell County Land Holdings, LLC, to Walter R. Greer. The deed had been a standard multi-parcel conveyance, each parcel identified by number in a schedule attached to the deed, the legal descriptions incorporated by reference from the individual parcel surveys. Parcel CW-002-0017 had been listed as a 34-acre tract in the northeastern section of the assemblage. The deed had contained a standard exceptions clause, subject to all easements, restrictions, covenants, and encumbrances of record. No specific easements or encumbrances had been identified for CW-002-0017 in the schedule. David had noted, no specific encumbrances identified in conveyance for spring parcel. Standard exceptions clause. Title examiner at closing apparently found no recorded instruments affecting parcel. Step 2. Caldwell County Land Holdings LLC's acquisition. The deed recorded March 3, 2021, conveying CW-002-0017 from the Caldwell County Superior Court's registry to Caldwell County Land Holdings LLC following a quiet title proceeding. David had pulled the quiet title action. Case number CW-2021-CV-0034. Filed January 2021, the petition naming Blue Ridge Water Holdings LLC as the last recorded owner and asserting abandonment of the property interest based on the LLC's dissolution in 2019 and the absence of any recorded activity on the parcel since the 2014 acquisition. The court had granted the quiet title petition in February 2021, vesting title in Caldwell County Land Holdings LLC as the petitioner. David had noted, quiet title proceeding 2021. Prior owner Blue Ridge Water Holdings LLC, dissolved 2019. Parcel held by dissolved LLC for 5 years, with no recorded activity. Quiet title clears encumbrances, to extent they were identified in the proceeding. Check what encumbrances were identified. He had pulled the quiet title petition's exhibit list. The title search attached to the petition showed no recorded easements or encumbrances on CW-002-0017 beyond the standard utility easements. The water main running east under the boundary fence had not been identified as a recorded instrument in the quiet title petition. It had not appeared in the petition's exhibit list because it had never been recorded. There was no recorded instrument for it to find. Step 3. Blue Ridge Water Holdings LLC's acquisition. The deed recorded June 12, 2014, conveying CW-002-0017 from Marcus Allen Teal, individually, to Blue Ridge Water Holdings, LLC, for a stated consideration of $85,000. A single parcel conveyance, the deed 2 pages, the legal description on page 2. No exceptions identified beyond the standard clause. No reference to any water use easement, utility easement, or water service agreement. David had noted, Teal to Blue Ridge Water Holdings, June 2014, $85,000. No easements reserved, no water use agreement referenced. Teal conveyed the spring parcel without retaining any recorded instrument authorizing the subdivision's continued use of the spring or the infrastructure. Step 4. Marcus Teal's acquisition. The deed recorded in connection with the Clearwater Pines development. David had found this instrument by searching the grantor-grantee index for Marcus Allen Teal and Caldwell County, which had produced a series of instruments from 2006 through 2014. The original acquisition had been a 2006 deed, conveying 340 acres, the land that would become both the Clearwater Pines subdivision and parcel CW-002-0017, from a farming family named the Hendersons to Valley Ridge Development LLC, an entity controlled by Marcus Teal. Teal had then platted the subdivision lots from the eastern 306 acres, while retaining the western 34 acres, the spring parcel, as a separate holding. He had sold the 54 subdivision lots between 2008 and 2012, and had retained the spring parcel until the 2014 sale to Blue Ridge Water Holdings. David had noted, Teal retained the spring parcel when he sold the subdivision lots. He sold the spring parcel separately in 2014 to Blue Ridge Water Holdings. He recorded no easement for the water main or the HOA's continued use of the spring at any point, not when he sold the lots, not when he sold the spring parcel. The subdivision lots were sold without any recorded water access instrument referencing the spring. Step 5. The individual lot deeds. David had pulled a sample of the Clearwater Pines lot deeds, 5 of the 54, chosen from different years of sale to capture the full development period. He had read each one, looking for any reference to the water source, the spring parcel, a water service agreement, or a utility easement for the water main. Not one of the 5 deeds contained any such reference. The lots had been sold with standard subdivision covenants, CC and RS for the HOA, and utility easement language for the standard underground utilities, electric, gas, telephone. None had referenced the spring on parcel CW-002-0017. None had disclosed that the subdivision's water supply came from a spring on a separate parcel that was not owned by the HOA. David had written, "Individual lot deeds contain no reference to water source. Buyers received no disclosure of spring dependency. Subdivision sold as if water supply were a standard utility. Source not disclosed. No easement recorded." He had then moved to the Georgia Environmental Protection Division's water use permit records. Georgia's water use reporting program required permits for withdrawals above a threshold volume, a threshold that a spring supply serving 54 homes would exceed. David had searched the EPD's online permit database for Caldwell County, filtering for water withdrawal permits associated with the Clearwater Pines development, the spring parcel, and the names Marcus Teal and Blue Ridge Water Holdings. He had found one permit, permit number WU-2008-CW-0441, issued August 2008, permittee, Marcus Allen Teal, individual. The permit had authorized withdrawal from the spring on parcel CW-002-0017 for the purpose of residential water supply to the Clearwater Pines subdivision development. The permitted withdrawal volume was 72,000 gallons per day, consistent with 54 homes at average Georgia residential consumption. The permit had been issued for an initial 5-year term, with a renewal obligation at year 5. The permit had not been renewed. The renewal deadline had been August 2013. No renewal application had appeared in the EPD's records for permit number WU-2008-CW-0441. The permit had expired in August 2013, 5 years after issuance, 3 years before David had initially estimated based on the date Walt had given him. David had rechecked. The initial term was 5 years, not 8. The permit had expired in August 2013, not 2016. He had noted the correction. Permit expired August 2013, 9 years ago, not 6. No renewal application filed. Permit lapsed without renewal. He had then checked whether any subsequent permit had been issued for the same source, a permit in Blue Ridge Water Holdings' name after the 2014 acquisition, or a permit in the HOA's name at any point. He had searched the EPD's full permit database for Caldwell County water withdrawal permits associated with the spring parcel's coordinates, the parcel number, and the subdivision name. No subsequent permit existed. From August 2013 to the present, 9 years, the Clearwater Pines subdivision had been withdrawing water from the spring on parcel CW-002-0017 without a valid water withdrawal permit. The permitted authority had expired. It had been held in Marcus Teal's personal name, not the HOA's name, not the subdivision's name, not any entity that had survived Teal's 2014 sale of the spring parcel. When Teal sold the parcel, the permit had already been expired for a year. Blue Ridge Water Holdings had held the parcel for 5 years without obtaining a permit. The HOA had been operating without any permit authority since 2013. David had written, "No valid water withdrawal permit has existed for this spring since August 2013. The HOA has operated without permit authority for 9 years. The permit was in Teal's personal name and was never transferred, renewed, or replaced." He had then searched for the easement, the instrument that should have existed if anyone in the chain had done the transaction correctly. A utility easement for the water main crossing the boundary fence, a water service agreement between the spring parcel owner and the HOA, a recorded covenant running with the subdivision lots referencing the water source, a license agreement, anything. He had searched the Caldwell County deed index by every methodology available: grantor name, grantee name, parcel number, instrument type. He had searched for Marcus Allen Teal as grantor of any easement instrument. He had searched for Blue Ridge Water Holdings as grantor or grantee of any instrument. He had searched for Clearwater Pines HOA as grantee of any water rights instrument. He had searched the parcel CW-002-0017 instrument history for any recorded encumbrance beyond the standard utility easements. He had found nothing. No utility easement for the water main, no water service agreement, no license, no covenant, no recorded instrument of any kind authorizing the HOA or any Clearwater Pines resident or entity to use the spring, the cistern, the pump house, or the water main on parcel CW-002-0017. He had sat with the completed search results for a few minutes, the deed index results on one monitor, the EPD permit database on the other, his examination notes filling 2 pages of his legal pad. 22 years of water rights practice had produced other cases where a water source was being used without proper legal authorization, shared well disputes, irrigation water disputes, municipal supply disputes, but he could not immediately recall a case where a residential subdivision of 54 homes had been drawing its entire water supply from a private spring on an adjacent parcel for 14 years with no recorded instrument of any kind and no valid permit for 9 of those years. He had called Walt at 4:15 p.m. on Friday. Walt had answered on the first ring. He had been at the farmhouse desk since 3 p.m., the parcel map in front of him, waiting for David's call. David had said, "Walt, I have the complete title and permit picture. I want to walk you through it." Walt had said, "Go ahead." David had said, "I'll start with the chain of title." Teal acquired the spring parcel as part of his original 340-acre development site in 2006. He built the subdivision on the eastern 306 acres and retained the western 34 acres, the spring parcel, as a separate holding. He installed the spring collection system and the water main in 2008 to serve the subdivision. He sold the 54 lots between 2008 and 2012 without recording any easement for the water main or any water service agreement authorizing the HOA's use of the spring. He then sold the spring parcel in 2014 to Blue Ridge Water Holdings for $85,000. He recorded no easement at the time of that sale either. When he sold the spring parcel, he walked away from the transaction without leaving any recorded instrument that connected the HOA's water supply to its source. Walt had said, he sold the water supply out from under the subdivision. David had said, he sold the spring parcel without reserving the access rights that would have made the subdivision's water supply legally secure. Whether he understood what he was doing is a question for another day. What he did is documented in the deed records. He had continued. Blue Ridge Water Holdings held the spring parcel from 2014 to 2019 without obtaining a water use permit, without recording a water service agreement with the HOA, and without any apparent activity on the parcel beyond holding it. The LLC dissolved in 2019 without any recorded disposition of the parcel. No deed out, no assignment, nothing. The parcel sat in limbo until the 2021 quiet title proceeding. The quiet title petition identified no recorded encumbrances because there were none to identify. The parcel was cleared and acquired by Caldwell County Land Holdings LLC, which included it in the assemblage it sold to you in 2022. Walt had said, the permit. David had said, Teal obtained a water withdrawal permit from the Georgia EPD in August 2008. Permit number WU-2008-CW-0441, in his personal name, authorizing withdrawal from the spring for residential water supply to the subdivision. The permit had a 5-year term with a renewal obligation at year 5. The renewal deadline was August 2013. No renewal application was filed. The permit expired in August 2013, 9 years ago. Walt had been quiet for a moment. He had said, 9 years without a permit. David had said, the permit was in Teal's personal name. It was not transferred to the HOA when Teal sold the lots. It was not transferred to Blue Ridge Water Holdings when Teal sold the spring parcel. It expired in 2013 before the 2014 sale. No subsequent permit was issued in any name for this spring. The HOA has been operating without any permit authority since August 2013. Walt had said, and the easement. David had said, "There is no easement, no utility easement for the water main, no water service agreement, no license, no recorded covenant referencing the water source. I searched the deed index by every method available, by grantor name, grantee name, parcel number, and instrument type. There is no recorded instrument of any kind authorizing the HOA or any Clearwater Pines entity to use the spring, the cistern, the pump house, or the water main on parcel CW-002-0017. He had paused. He had said, "Walt, 54 homes have been drawing their entire water supply from your spring for 14 years with no legal basis. The permit that existed expired 9 years ago and was never in the HOA's name to begin with. There is no easement. There is no agreement. There is nothing." Walt had said nothing for 4 seconds. David had said, "The infrastructure, the cistern, the pump house, the water main, is on your property, all of it. The main crosses the boundary under the fence with no recorded easement for the crossing. Every gallon of water those 54 homes have used since 2008 has come from your spring under a legal arrangement that does not exist." Walt had said, "What is the HOA's position under Georgia water law?" David had said, "Georgia water law recognizes the landowner's right to water originating on their property, subject to the state's regulated riparian framework. The spring originates on your land. The collection system is on your land. The HOA has no permitted authority to withdraw from the spring, and no recorded property right to access the infrastructure. Their position under Georgia law is that they are using a private water source on private property without authorization. The term for that, in plain language, is unauthorized use." Walt had said, "What is the process?" David had said, "We notify the HOA of the water rights situation, demand that they regularize the unauthorized use through a negotiated water service agreement, and give them a reasonable period to respond. We also file an EPD notification of the unauthorized withdrawal. The HOA has been operating without a permit for 9 years, and the EPD needs to know. The EPD notification is not punitive, it is required disclosure, but it will focus the HOA's attention considerably." Walt had said, "Do the notification and the demand simultaneously." David had said, "That was my recommendation, yes." Walt had said, "One more question. The fence letter. The HOA president sent me a letter about the boundary fence I'm installing. I received it last week." David had said, "What does it say?" Walt had said, "She wants me to remove a section of the fence because it interferes with their landscaping contractor's access to the eastern boundary. She says the HOA has historically maintained the vegetation along the boundary, and that my fence prevents their contractor from accessing the area." David had been quiet for 3 seconds. He had said, "She sent you a fence complaint letter." Walt had said, "Last Tuesday, before I found the water main." David had said, "She doesn't know about the water system." Walt had said, "I don't believe she does. The letter is entirely about the fence." David had said, "Walt, keep the fence letter. We are going to answer it, and we are going to attach the water rights notice to the answer." Walt had said, "That was my thinking." David had said, "Give me 2 weeks to prepare both documents. I want the water rights notice to be complete, the title chain, the permit history, the legal analysis, the demand. When Renee Cobb reads the answer to her fence letter, she is going to understand the full dimensions of her situation before she has had any opportunity to prepare for it." Walt had said, 2 weeks. He had ended the call and had looked out the farmhouse window toward the northeastern section of the property. The spring, the cistern, the pump house, the 4-inch main running east under the boundary fence into a subdivision whose president had sent him a letter about a fence. The spring discharged at 84 gallons per minute. It had been doing so since before Marcus Teal broke ground in 2008. It would keep doing so long after every document David was about to prepare had been filed and recorded, and the situation had been resolved into whatever it was going to become. Walt was going to make sure that resolution rested on a proper legal foundation. For the first time since 2008, it was going to. Renee's letter had arrived on a Tuesday, 2 pages on Clearwater Pines HOA letterhead, dated the previous Thursday, The complaint centered on the northern 400 feet of the boundary fence Walt had been installing along the eastern property line. Walt had read it at the farmhouse desk with his morning coffee. The letter had described the fence as impeding access to the vegetative buffer zone that the HOA has historically maintained along the shared boundary. Renee had written that the HOA's landscaping contractor had maintained the vegetation along the boundary for 14 years, and that Walt's fence posts, set on the property line, prevented the contractor from accessing the area from the subdivision side. She had demanded that Walt remove the fence section, or relocate it 4 feet west of the boundary line within 30 days. She had cited the HOA's historical maintenance rights along the boundary as the basis for the demand. The letter had closed with a PS requesting Walt's property manager's contact information for future boundary matters. Walt had read the letter twice. He had noted that it contained no recorded easement reference, no legal citation, and no instrument of any kind establishing the historical maintenance rights Renee had invoked. He had set it on the desk and had called David. David had said, "Is there a recorded easement for landscaping access along the boundary?" Walt had said, "I searched the deed index before I started the fence project. Nothing." David had said, 14 years of a contractor's periodic visits does not create a legal access right under Georgia law. She has a habit, not a right. We answer the fence letter directly. 1 paragraph. The fence stays. The demand is without legal basis. And we attach the water rights notice as Exhibit A. Walt had said, as a separate document. David had said, formally headed, attached to the fence response. The fence response tells her the fence stays. Exhibit A tells her why the fence is the least of her concerns. Give me 2 weeks. The 2 documents had gone out by certified mail and email on a Thursday morning 14 days later. The cover letter had been 3 paragraphs. The fence was lawfully installed on the property line as surveyed. The demand to relocate it was declined. The HOA had no recorded easement authorizing access to the boundary area from Walt's side. 14 years of a contractor's visits did not establish a legal access right, and the contractor could access the boundary vegetation from the subdivision side. The 3rd paragraph had read, "Please review the attached Exhibit A, which addresses a separate matter of greater significance to the Clearwater Pines community." Exhibit A had been 14 pages. The opening section had stated the legal conclusion without qualification. The spring, the collection cistern, the pump house, and the 4-inch water main on Mr. Greer's side of the boundary are located on parcel CW-002-0017, which is owned in fee simple by Walter R. Greer. No portion of the water supply infrastructure serving the Clearwater Pines subdivision that is located on Mr. Greer's property is owned by, leased to, or subject to any easement held by the Clearwater Pines HOA or any Clearwater Pines lot owner. The chain of title section had traced the ownership sequence. Marcus Teal's 2006 acquisition of the original 340-acre site, his development of the subdivision on the eastern 306 acres while retaining the spring parcel, the 54 lot sales between 2008 and 2012 with no recorded water easement in any deed, the 2014 sale of the spring parcel to Blue Ridge Water Holdings with no easement reserved, the LLC's 2019 dissolution, the 2021 quiet title proceeding, Walt's 2022 acquisition, each instrument identified by its recording reference, the chain unbroken, and the absence of any easement consistent at every step. The permit section had addressed Georgia EPD permit number WU-2008-CW-0441, issued August 2008 to Marcus Allen Teal personally, authorizing withdrawal from the spring for residential water supply to the subdivision. The permit had a 5-year term. The renewal deadline had been August 2013. No renewal application had been filed. The permit had expired in August 2013, 9 years prior to the notice. No subsequent permit had been issued in any name for the spring. The section had closed with a single declarative sentence. The Clearwater Pines subdivision has operated without a valid water withdrawal permit for this spring since August 2013. The legal analysis section had applied Georgia water law, the landowner's rights to water originating on their property, the absence of any recorded instrument authorizing the HOA's use, The legal characterization of the HOA's continued withdrawal as unauthorized use of a private water source on private property. The demand section had stated 4 numbered items. 1. The HOA shall immediately acknowledge, in writing, Mr. Greer's ownership of the spring, the cistern, the pump house, and the water main on parcel CW-002-0017. 2. The HOA shall cease unauthorized withdrawal from the spring, pending the execution of a negotiated water service agreement with Mr. Greer. 3. The HOA shall file an application for a water withdrawal permit with the Georgia EPD within 30 days, naming Mr. Greer as the water source owner and the HOA as the withdrawal entity. 4. The HOA shall negotiate in good faith a recorded water service agreement and utility easement with Mr. Greer, authorizing the continued use of the spring on terms to be determined. The notice had closed with a paragraph David had written with particular care. Mr. Greer acquired this property in April 2022 and became aware of the water supply infrastructure during routine boundary work in July 2022. He has no desire to disrupt the water supply of 54 households. His desire is to have the legal relationship between his property and the subdivision's water infrastructure placed on a proper, recorded foundation. A foundation that should have existed since 2008, and that Marcus Teal's failure to record a water use easement left absent from the title chain. Mr. Greer is prepared to negotiate a water service agreement that provides the HOA with long-term, legally secure access to the spring. He is not prepared to allow that access to continue without legal authorization. Renee had received the envelope on a Saturday morning. The certified mail delivery at 9:47 a.m. The envelope opened at her kitchen table with her second cup of coffee. She had read the cover letter in 2 minutes. The fence response had annoyed her, the new neighbor declining to cooperate about something that had always been done a certain way. She had been composing her mental response to the fence argument when she unfolded Exhibit A. She had read the title, Water Rights Notice, Parcel C, W-002-0017, Clearwater Pines Subdivision Water Supply. She had read the first paragraph of the ownership section. She had read it again. She had set the document on the table and looked at it and then picked it up and read the first paragraph a third time. The spring, the cistern, the pump house, the water main, all on Walt Greer's property. No easement, no lease, no instrument of any kind. She had read the permit section. She had read the expiration date, August 2013, 9 years ago. She had gotten up from the kitchen table and walked to the utility room where the water meter was located. The digital display showing current reading, the supply pipe coming up through the floor from the underground main. She had looked at the meter for a moment. She had then walked back to the kitchen and called the HOA's automated water system status line. The automated message had said, current system status, normal operation, supply pressure, 52 pounds per square inch, no service interruptions. Normal operation. She had set the phone down and looked at Exhibit A on the kitchen table. 14 pages. The title chain. The permit history. The legal analysis. The demand. She had called Dale Pruitt at Lot 31, the retired banker who had been on the HOA board for 6 years, and whose judgment she trusted when the situation was genuinely serious. She had said, Dale, I need you to come over. I've received something the board needs to see immediately. Dale had arrived in 12 minutes. He had read Exhibit A at the kitchen table without speaking. He had read the permit section twice. He had set the document down and looked at Renee. He had said, we need an attorney. Renee had said, I'm calling one Monday morning. Dale had said, call one today. This is not a Monday morning situation. Renee had picked up her phone. The spring on parcel CW-002-0017 had discharged at 84 gallons per minute on that Saturday morning, the same rate it had discharged at on every morning since the limestone aquifer had been pushing water through the fracture in the rock shelf for longer than anyone in the Clearwater Pines subdivision had been alive. The water running through 54 homes on that Saturday morning was Walt Greer's water. It had always been Walt Greer's water. Now Renee Cobb knew it. Pamela Shore had taken the call on a Saturday afternoon. Her cell phone, the number Dale Pruitt had obtained from a colleague at his former bank, who had used her firm for a commercial property dispute 3 years earlier. Renee had called at 2:15 p.m., 4 hours after Dale had read Exhibit A at the kitchen table and told her not to wait until Monday. Pamela had listened to Renee's summary for 6 minutes without interrupting. The new neighbor, the fence complaint, the attached water rights notice, the spring, the permit expiration, the absence of an easement. She had asked 3 questions: the parcel number for the spring parcel, the name of Walt's attorney, and whether the HOA had any documents relating to the water system in its files. Renee had said, "I'll have to check the HOA's records. We have files going back to the HOA's formation in 2008. I don't know what's in them relating to the water system." Pamela had said, "Pull everything you have on the water system. Any contracts, any permit documents, any correspondence with Marcus Teal or any water authority, any infrastructure records. I need to see all of it before I can give you a complete assessment. I'll start my own research Monday morning." She had said, "Ms. Cobb, I want to be straightforward with you before we go further. The notice you've described is legally detailed, and the factual claims it makes are verifiable from public records. Before you decide how to respond, I need to know whether those claims are accurate. That research takes a few days. Don't send any response to Mr. Greer's attorney until I've completed the review." Renee had said, "How long?" Pamela had said, "By Thursday. Don't respond before Thursday." She had started Monday morning at 7:30 with the Caldwell County Deed Index, the same index David had searched 2 weeks earlier, the same methodology, the same sequence. She had pulled parcel CW-002-0017 first, and had traced the chain of title backward from Walt's 2022 deed to Teal's 2006 acquisition. The chain had confirmed every claim in David's notice: the 2014 sale to Blue Ridge Water Holdings, with no easement reserved; the LLC's 2019 dissolution; the 2021 quiet title proceeding; Walt's 2022 acquisition. She had then searched the adjacent parcel records, the Clearwater Pines subdivision's common area parcel, and a sample of 10 individual lot deeds. She had been looking for what David's notice said was not there: a recorded water use easement, a utility easement for the water main, a water service agreement, any instrument connecting the subdivision's water supply to its source on the spring parcel. She had found nothing. The lot deeds were standard subdivision conveyances, the standard HOA covenants, the standard utility easements for electric and gas and telephone, nothing referencing the water source. The common area parcel deed had the same profile. No water rights instrument appeared anywhere in the subdivision's recorded title chain. She had then pulled the Georgia EPD permit database. Permit number WU-2008-CW-0441 had loaded on her screen in the same form David had seen. The 2008 issuance, Marcus Teal as permittee, the 5-year term, the August 2013 expiration. She had checked the renewal records more thoroughly than the notice had described, looking for any renewal application that might have been filed late, any extension request, any successor permit in any name. She had searched the EPD's database by the spring's GPS coordinates, the parcel number, the subdivision name, and every entity name in the chain of title. There was no subsequent permit. The database showed 1 permit for this source and 1 expiration date, and nothing after it. She had noted, 9 years of unpermitted withdrawal confirmed. EPD permit database contains no successor permit in any name. She had then called the Georgia EPD's water withdrawal program directly, a staff member named Kevin Marsh, who handled compliance inquiries for the North Georgia region. She had described the situation in general terms: a residential subdivision of 54 homes drawing water from a private spring. The original permit expired 2013. No successor permit, the spring parcel having changed ownership twice since the permit expiration. Kevin had said, "That's a significant compliance issue. An unpermitted withdrawal at that volume for that duration. The EPD would be very interested in that situation. Has someone filed a complaint?" Pamela had said, "Not yet to my knowledge. I'm doing due diligence for a client." Kevin had said, "If this comes to us officially, we'll be required to open a compliance review. The subdivision would need to obtain a permit retroactively or cease withdrawal. If they're drawing from a private landowner's spring without a recorded authorization from the landowner, That's a separate property rights issue on top of the permit compliance question. Pamela had said, "Understood. Thank you." She had noted, EPD confirmation that unpermitted withdrawal at this volume triggers mandatory compliance review if reported. Property rights issue separate from permit compliance. On Wednesday, she had driven to the Caldwell County Courthouse and had reviewed the physical deed files for the Clearwater Pines subdivision, the original development plat, the subdivision approval documents, the infrastructure records on file with the county. She had found the subdivision's original utility plan, the engineering drawings submitted with the development permit application in 2007, the drawings showing the water supply system, the spring on parcel CW-002-0017, the collection cistern, the pump house, the 4-inch main running east under the boundary between the spring parcel and the subdivision parcel. The utility plan had been stamped by the county's engineering office in 2007 as part of the subdivision permit approval. The stamp had noted, water supply system, private spring, permit required from Georgia EPD prior to construction. The EPD permit, WU-2008-CW-0441, had been obtained in 2008, 1 year after the county's stamp. The utility plan had been approved on the condition that the permit would be obtained. The permit had been obtained. Then it had expired in 2013 and had never been renewed, and the system had continued operating for 9 more years on the momentum of an infrastructure that nobody in the chain of ownership had ever thought to examine legally. Pamela had pulled the HOA's formation documents from the county's HOA registry. The HOA had been formed in 2008, the same year the subdivision opened. The formation documents listing the HOA's purposes and responsibilities. The water system had not been listed as an HOA asset. The formation documents had not referenced the spring parcel or any water use agreement. The HOA had been formed as if the water supply were a standard utility. Source unspecified. Responsibility unassigned. Legal basis unexamined. She had driven back to Atlanta on Wednesday evening with a complete picture and had called Renee on Thursday morning at 9 a.m. She had said, "Renee, Pamela Shore, I've completed my review. I want to give you the full assessment before you decide on next steps." Renee had said, "Go ahead." Pamela had said, "Every factual claim in Mr. Greer's water rights notice is accurate. I've verified each one independently. The spring is on his property, parcel CW-002-0017, owned by Walt Greer in fee simple since April 2022. The cistern, the pump house, and the water main on his side of the boundary are all on his property. There is no recorded easement, no utility easement, no water service agreement, and no recorded instrument of any kind authorizing the HOA's use of the spring or the infrastructure." Renee had been quiet. Pamela had said, "The Georgia EPD permit expired in August 2013. That is 9 years ago. The permit was issued in Marcus Teal's personal name. It was never transferred to the HOA, never transferred to Blue Ridge Water Holdings when Teal sold the spring parcel in 2014, and was never renewed. There is no successor permit in any name. The HOA has been withdrawing water from this spring without a valid permit for 9 years. Renee had said, "Marcus Teal built this system. He is responsible for this." Pamela had said, "Teal's responsibility for the situation he created is a separate legal question from your current unauthorized use of Walt Greer's water source." I want to be clear about that distinction because it is important for how you think about the path forward. Yes, Teal sold 54 lots without disclosing that the water supply came from a separate parcel he retained. Yes, he sold the spring parcel in 2014 without recording a water use easement that would have secured the subdivision's access. Those failures created the situation, but the situation you are in today is not resolved by Teal's responsibility. You have been drawing water from Walt Greer's property since he acquired it in 2022 without his knowledge or authorization. That is the problem in front of you. Renee had said, "He bought the property in 2022. He's only owned it for a few months. The HOA has been using this water for 14 years. Pamela had said, "Georgia law does not provide the HOA with rights against a new landowner based on years of unrecorded use. The use was against prior owners. Teal, Blue Ridge Water Holdings, who did not object. Walt Greer did not know about the use when he acquired the property. When he discovered it, he gave notice. His notice is legally correct. The HOA's position against him is not strengthened by the duration of the unauthorized use. Renee had said, "What are our options?" Pamela had said, 2. Negotiate a water service agreement with Mr. Greer on terms he will accept, which gives the HOA long-term, legally secure access to the spring. Or, develop an alternative water supply, drill a production well on HOA common area land, connect to a public utility if one serves the area, or identify another source. The alternative supply route is a significant infrastructure project that would take months and cost substantially more than a negotiated agreement. Renee had said, "And if we do nothing?" Pamela had said, "If you do nothing, Mr. Greer's attorney will escalate, a court filing seeking a declaration of unauthorized use and an injunction against continued withdrawal, potentially combined with an EPD complaint that triggers a mandatory compliance review. If the EPD opens a compliance proceeding on a 9-year unpermitted withdrawal at 54-home scale, the HOA will be dealing with a regulatory enforcement action on top of the civil dispute. I do not recommend doing nothing." Renee had said, "I need to tell the board." Pamela had said, "Tell the board, then tell the community. The 54 households have a right to know that their water supply is legally unsecured. They are going to find out regardless. Better that they hear it from you in a measured way than from Mr. Greer's attorney in a court filing." Renee had said, "This is going to cause panic." Pamela had said, "It is going to cause concern. Whether it causes panic depends on how you present it. The water is still flowing. Mr. Greer has stated he does not want to disrupt the supply. His notice says he wants to negotiate, not to shut it off. Present it accurately. There is a legal issue with the water supply's authorization that the board is addressing. The supply is currently uninterrupted, and the board is in discussions to put the authorization on a proper legal footing. That is accurate, and it is not panic-inducing if delivered calmly." Renee had said nothing for a moment. She had said, "I'll call a board meeting for tonight." The board meeting had been at 7 p.m. in the community room, the 5 board members, Pamela joining by phone. Renee had presented the situation in 30 minutes, the Exhibit A document on the table, Pamela's assessment delivered in summary. Dale Pruitt had asked the questions the other board members had not yet formed. What is the exposure if Greer files before we respond? What is the EPD's likely timeline if a complaint is filed? What is the cost range for an alternative supply? Pamela had answered each one. The exposure was significant. A court finding of unauthorized use could support damages for the period of Walt's ownership, and potentially earlier if the court found the prior owners had no right to allow the use either. The EPD timeline was 30 to 60 days from complaint to compliance notice. An alternative supply, a production well on HOA common area land, would cost an estimated $180,000 to $250,000 based on the formation depth typical for the region, plus permitting and infrastructure. Dale had said, "The negotiated agreement is cheaper and faster." Pamela had said, "Substantially, and it provides long-term security. A production well could fail. The spring has been flowing at documented rates for as long as the records go back." The board had authorized Pamela to contact David Osai and request a negotiating session. Renee had then posted to the HOA community portal at 9:15 p.m. a message she had drafted with Pamela's input, 3 paragraphs, the tone measured and factual. The post had read, "The board has become aware of a legal matter involving the community's water supply. Our water comes from a natural spring that is located on property recently acquired by our neighbor, Mr. Walt Greer. The legal authorization for our use of the spring needs to be updated and properly recorded, and the board is working with legal counsel to negotiate a formal water service agreement with Mr. Greer. The water supply is currently uninterrupted, and Mr. Greer has indicated his intention to negotiate rather than disrupt service. The board will provide updates as the negotiation progresses. We understand this is concerning news, and we are committed to resolving it promptly." The post had received 34 replies by midnight. A resident named Patricia Hollis at Lot 12 had written, "Can someone explain how we have been using water from a neighbor's property for 14 years without a legal agreement? Who was responsible for making sure this was handled?" A resident named Tom Garrett at Lot 27 had written, "Marcus Teal built this subdivision. He sold us homes that depended on a water source he didn't secure the rights to. Where is Marcus Teal?" A resident named Susan Albright at Lot 44 had written, "I have 3 children. When you say the water is currently uninterrupted, what does currently mean? What happens if Mr. Greer decides to turn it off?" Renee had replied to Susan Albright, "Mr. Greer's notice states he wants to negotiate a formal agreement, not disrupt the supply. The board is moving quickly to reach that agreement." She had not replied to Tom Garrett's question about Marcus Teal. By morning, the portal had 67 posts. The dominant thread was not about Walt Greer. It was about Marcus Teal. Tom Garrett had posted again at 7 a.m. "I paid $340,000 for this house in 2011. I was never told my water came from a spring on a separate property with no legal agreement. That is material information that should have been disclosed. I want to know what the board's legal position is regarding Teal's liability to the 54 families who bought in this subdivision." The post had received 28 replies by noon. Pamela had called Renee at 10 a.m. and had said, "You're going to have a Teal problem running parallel to the Greer negotiation. The homeowners are going to want to pursue Teal. I can handle both tracks, but you need to understand that the Teal track is a separate proceeding with its own timeline and its own uncertainty. The Greer negotiation is the immediate priority because the water supply depends on it." Renee had said, "Can we make Teal pay for whatever Greer demands?" Pamela had said, "That is the theory of the Teal claim, that his failure to record a water use easement caused the HOA's current liability to Greer, and that the HOA's damages in the Greer negotiation are recoverable from Teal. It is a viable theory. The practical problem is that Teal is retired in Florida. The statute of limitations on the original transaction runs back to 2008, and Teal's attorneys will argue that the HOA had 14 years to discover the water system's legal status and failed to do so. The Teal claim is worth pursuing, but it will not resolve the Greer negotiation." Renee had said, "Get to the table with Greer's attorney." She had said it without her earlier resistance, the resistance of a person who had not yet understood the full dimensions of the situation. She understood them now. The spring was Walt Greer's. The permit had been expired for 9 years. There was no easement. 54 households were waiting for the board to fix something that should never have been left unfixed. Renee Cobb had sent Walt Greer a letter about a fence. The table was the only place this was going to be resolved. David had prepared the formal demand while Pamela was conducting her title review. The 2 attorneys working in parallel, each building the same factual record from the same public sources, each arriving at the same legal conclusion from opposite sides of the table. David had known from his Monday morning research that the HOA would retain counsel, and that counsel would verify his notice's claims, and would advise the HOA to negotiate. He had prepared the formal demand not to accelerate a confrontation, but to establish the complete record before the first negotiating session. A demand that documented every element of the unauthorized use claim, so that the negotiation began from a fully stated position, rather than from an opening offer that could be walked back. He had called Walt on the Wednesday of the second week, 2 days before he sent the documents to Renee, and had walked him through the demand's structure. He had said, "The demand has 3 components. The first is the acknowledgement. The HOA acknowledges in writing your ownership of the spring, the cistern, the pump house, and the water main on parcel CW-002-0017. No equivocation, no qualification. Written acknowledgement before anything else moves." Walt had said, "Agreed." David had said, "The second is the cessation demand. The HOA ceases unauthorized withdrawal from the spring pending a negotiated water service agreement." I want to be clear about the practical dimension of this. The demand is legally correct, and I am required to make it, but advising the HOA to actually shut off the water to 54 homes pending negotiation is not something Pamela Shore is going to recommend if she is doing her job. The cessation demand establishes the legal position. The practical resolution is the negotiated agreement that replaces the unauthorized use with authorized use. The demand and the practical path are parallel, not sequential. Walt had said, "I understand the distinction. The demand is the legal statement. The agreement is the resolution." David had said, "Correct. The third component is the compensation figure. This is where I want to spend some time." The compensation analysis had taken David the better part of 2 days. the methodology built on the same framework he used in other unauthorized water use cases, adjusted for the specific facts of a 14-year residential supply situation in Georgia. The foundation had been the reasonable value of the water use, what the HOA would have paid for authorized access to the spring if a water service agreement had been negotiated in 2008 when the subdivision opened. David had benchmarked this against three comparables: private water service agreements in North Georgia involving spring-fed residential systems, the standard rate structures used by small private water utilities serving comparable residential populations, and the Georgia PSC's rate data for small water systems serving 50 to 100 connections. The comparable analysis had produced a benchmark annual service fee range of $18,000 to $26,000 per year for a spring system serving 54 residential connections at the measured discharge rate, a range that reflected the spring's productivity, the infrastructure's capacity, and the market rate for comparable private water service in the region. David had applied the midpoint of the range, $22,000 per year, across the unauthorized use period. The HOA had been using the spring since August 2008. Walt had acquired the property in April 2022. The unauthorized use period against Walt specifically ran from April 2022 to the date of the notice, approximately 4 months, at the annual rate producing a figure of approximately $7,300. But David had extended the analysis backward, not as a claim against Walt's predecessors, which was not David's case to make, but as context for the full scope of Thiel's error and the HOA's exposure. From August 2008 to April 2022 was 13 years and 8 months. At $22,000 per year, the total unauthorized use value across the full period was approximately $301,000. The HOA's direct liability to Walt for the period of his ownership was $7,300 plus ongoing accrual. The HOA's broader exposure for the full 14-year period, the exposure that would inform the Thiel litigation, was $301,000. David had presented the compensation demand to Walt as two figures: the direct demand against the HOA for the period of Walt's ownership, $7,300, plus $1,833 per month of continued unauthorized use from the notice date to settlement, and the broader 14-year figure as context for the negotiation stakes. Walt had said, "The direct figure is modest." David had said, "The direct figure reflects the period of your ownership. The demand is against the HOA for what it owes you, not for what it owes Thiel's victims, which is a separate claim. The $7,300 is what 14 years of unauthorized use costs the HOA in direct liability to you for the 4 months you've owned the property. The ongoing accrual, $1,833 per month, is what motivates the HOA to negotiate quickly." Walt had said, "The compensation figure in the demand." David had said, $7,300 plus accrual. The settlement number will be higher because the negotiation will take months and the accrual will run. By the time we are at the table, the direct figure will be in the range of $18,000 to $25,000, depending on the negotiation timeline. The compensation is not the central issue in the demand. The recorded acknowledgement and the water service agreement are the central issues. The compensation establishes that unauthorized use has a cost that accrues daily. Walt had said, "Send the demand." The formal demand had gone to Pamela Shore on the same Thursday morning as the cover letter and Exhibit A to Renee, a separate document, the third element of the package David had assembled. It had been 6 pages, the unauthorized use characterized under Georgia water law, the compensation methodology explained in detail, the 3 demand elements stated in numbered paragraphs, the response deadline set at 30 days. Pamela had received it and had called David that afternoon. She had said, "David, Pamela Shore, I represent the Clearwater Pines HOA. I've reviewed your notice and demand. I want to have a preliminary conversation before either of us files anything." David had said, "I'm happy to talk. My client's position is stated in the documents." Pamela had said, "I've completed my title review. The factual claims in your notice are accurate. I've advised my client accordingly. The HOA wants to negotiate." David had said, "Mr. Greer is prepared to negotiate." The demand's 30-day response window is the timeline for a written response, indicating the HOA's intent. The negotiating session can be scheduled within the 30 days or after. The accrual runs either way. Pamela had said, "We'll respond within 30 days. I need some time to work through the board's internal situation before we can set a date." David had said, "Understood, the meter is running." The internal situation Pamela had referenced was the HOA board's parallel effort to understand the full scope of Teal's liability, an effort that had been running since the community portal erupted, and Tom Garrett's question about Marcus Teal had received 28 replies. Renee had tasked Dale Pruitt with finding Marcus Teal's current contact information, a task Dale had completed in 2 days through a combination of Florida property records and a LinkedIn search that produced a profile listing Teal as a retired developer in Sarasota. Dale had found a phone number through a mutual contact in the Georgia development industry, a man who had done site work for Teal on a project in 2010 and who still had Teal's cell number in his contacts. Renee had called the number on a Thursday evening. A man had answered. She had said, "Is this Marcus Teal?" He had said, "Who's calling?" She had said, "Renee Cobb. I'm the president of the Clearwater Pines HOA in Caldwell County, Georgia. You developed Clearwater Pines in 2008. There had been a pause. He had said, "I developed a lot of properties. What's this about?" She had said, "The water supply system you installed for the subdivision, the spring on the parcel you retained and sold in 2014. The spring is now owned by our neighbor. There is no recorded easement authorizing our use of it. The new owner has sent a formal demand. 54 families are affected. I need to talk to you about your responsibility for this situation." There had been a longer pause. He had said, "You need to talk to my attorney." She had said, "Mr. Teal, 54 families bought homes in your subdivision without knowing their water came from a spring you didn't secure the rights to. You sold that spring parcel in 2014 without recording an easement. You need to understand what that decision has caused." He had said, "My attorney's name is Robert Finch. He's in Atlanta. I'll have him call you." He had ended the call. Robert Finch had called Pamela Shore, not Renee, on Monday of the following week. The call had been brief, and its content had been what Pamela had expected. Finch had said, "I represent Marcus Teal. My client sold parcel CW-002-0017 in June 2014 by a recorded deed to Blue Ridge Water Holdings, LLC. The transaction was properly documented, and the parcel was conveyed without encumbrance, as the deed stated. My client has no current obligation with respect to the parcel or the subdivision's water supply. Any claim the HOA believes it has arising from the 2008 development should be addressed through the applicable statute of limitations analysis, which I expect will be dispositive." Pamela had said, "The HOA's position is that Teal's failure to record a water use easement at the time of the subdivision development or at the time of the 2014 spring parcel sale constitutes a breach of the implied warranty of habitability and a failure to disclose a material fact affecting the lot's value and use. The statute of limitations question depends on when the claim accrued, a question that turns on when the HOA and the individual homeowners knew or should have known about the water system's legal status." Finch had said, "My client disputes that characterization and will assert the statute of limitations defense if any claim is filed. He has instructed me to convey that he sold the parcel legally in 2014, and that the HOA's current situation is a result of subsequent ownership changes that he had no role in and no ability to control." Pamela had said, "I'll convey that to my client." She had called Renee after the call with Finch and had said, "Teal's attorney is claiming no current obligation and will assert the statute of limitations. He is not going to volunteer a contribution to the settlement. If the HOA wants to pursue Teal, it will be through litigation, a complaint filed against him in Georgia courts, serving him in Florida, litigating the statute of limitations question, and ultimately trying the liability case. That is an 18-month proceeding minimum, and the outcome is uncertain." Renee had said, "So he just walks away?" Pamela had said, "For now, yes. The HOA's immediate path is the Greer negotiation. The Teal claim is a separate track that the board can authorize after the Greer settlement is complete." Pursuing Teal while negotiating with Greer simultaneously is possible, but it divides the board's attention and the legal resources at a moment when the Greer negotiation needs to be the priority. Renee had said, "The homeowners are going to want to pursue him." Pamela had said, "They may be right to, but not before the water supply is secured." The board had met on the following Tuesday evening, the same community room, the same 5 board members. The energy in the room different from the previous meeting because the portal had now reached 140 posts, and 8 residents had sent individual emails to the board address, demanding a full accounting of how the water system's legal status had gone unexamined for 14 years. Renee had presented Pamela's complete assessment, the title chain, the permit history, the Teal call and Finch's response, the compensation demand, the negotiation path. She had presented it without the defensive framing she had used in the first meeting. The full assessment, delivered in the direct language Pamela had counseled, the board members absorbing the scope of the situation, without the mitigation of incomplete information. Dale had said, "The compensation demand, the accrual figure of $1,833 per month. We've been in Pamela's review and the 30-day response window for approximately 6 weeks. That's roughly $11,000 in additional accrual on top of the initial $7,300. Pamela had confirmed. The total direct compensation exposure to Mr. Greer as of the meeting date was approximately $18,600 and accruing at $1,833 per month. The settlement figure would be higher than the current accrual because the negotiation would take additional time. A board member named Cheryl Watts at Lot 18 had said, "Why didn't the HOA know about this? The water system has been operating since 2008. Didn't anyone ever look at where the water came from?" Dale had said, "The HOA was formed assuming the water system was secured. The formation documents don't reference the spring parcel. The individual lot deeds don't reference it. Every homeowner who bought in this subdivision bought assuming the water supply was a standard utility with proper legal authorization. That assumption was wrong from the beginning, and nobody in the chain, not Teal, not Blue Ridge Water Holdings, not the previous HOA boards, ever examined it." Cheryl had said, "The previous boards should have examined it." Dale had said, "Yes, they should have. We're examining it now." The board had voted to authorize Pamela to schedule a negotiating session with David Osai. The vote unanimous, Renee voting in favor without objection. The vote had also authorized the EPD permit application. The HOA would file with the Georgia EPD, naming Walt as the water source owner, and the HOA as the withdrawal entity, as David's demand had required, within the 30-day window. After the board vote, Renee had posted to the community portal a second update, longer than the first, the tone still measured but the content more complete. The compensation demand acknowledged, the Teal contact described, Finch's response summarized, the negotiation path confirmed as the board's immediate priority. Tom Garrett had replied within the hour. "So Teal's attorney says he has no obligation, and we're supposed to just accept that. We paid for homes whose water supply was legally unsecured from day one. That is not acceptable." 22 residents had replied in agreement. Pamela had read the thread on Thursday morning and had called Renee. She had said, "The Teal pressure from the community is going to build. You need to tell them the board is evaluating the Teal claim, but that the Greer negotiation comes first. Give them a timeline for when the board will make a decision on pursuing Teal." Renee had posted, "The board is evaluating all legal options with respect to the original developer's responsibility for the water system's legal status. We will report to the community on that question within 60 days of the Greer settlement. The immediate priority is securing the water supply." Tom Garrett had replied, "60 days is acceptable. We're watching." David had received the HOA's written response within the 30-day window. Pamela's letter, 3 pages, acknowledging the factual claims in Walt's notice, stating the HOA's intention to negotiate a water service agreement, confirming the EPD permit application had been filed, and requesting a negotiating session at a mutually convenient time. The letter had not included the written acknowledgement of Walt's ownership that the demand had required as the first item. It had said the HOA recognized Walt's ownership claims and was prepared to address them through negotiation. It had not used the word acknowledge and had not proposed the recorded instrument David had specified. David had called Walt after reading it. He had said, "They've responded within the window. They want to negotiate. The response doesn't include the written acknowledgement in the form I specified. It uses softer language that preserves their ability to walk back the ownership question if the negotiation breaks down. It's a standard opening position." Walt had said, "What do we do?" David had said, "We accept the negotiation invitation, and we make the recorded acknowledgement the first item on the table. They can soften the language in the preliminary correspondence all they want. The instrument that goes into the county deed records will say what I've drafted it to say, or the negotiation ends." Walt had said, "Set the date." David had called Pamela that afternoon. They had scheduled the negotiating session for 3 weeks out, a Tuesday morning in Atlanta, David's conference room. Walt and David on one side, Pamela and Renee and Dale Pruitt on the other. The spring had discharged at 84 gallons per minute on the morning David made that call, the limestone aquifer pushing water through the fracture in the rock shelf on parcel C W-002-0017 at the same steady rate it had been pushing it since before Marcus Teal had ever driven through Caldwell County looking for development land. The water had no opinion about the meeting scheduled for 3 weeks out. It moved the way water moved, through the path of least resistance, out of the rock, into the cistern, through the pump house, under the boundary fence, into 54 homes whose residents were watching the community portal and waiting for the board to fix something that Teal's error had left unfixed for 14 years. The table was set. The meter was running. The meeting had been on a Tuesday morning in David's Atlanta conference room. Walt and David on one side of the table, Pamela and Renee and Dale Pruitt on the other. Renee had arrived with a legal pad and the particular posture of a person who had spent 3 weeks preparing to negotiate from a position she knew was weak. Dale had arrived with a copy of the demand letter and his own legal pad. Pamela had arrived with the term sheet David had sent the previous week and 3 pages of handwritten notes. Walt had nodded at Dale when they sat down. Dale had nodded back. Renee had looked at the table. David had opened. He had said, "Mr. Greer has 4 terms for a water service agreement. I'll present them in order, and we can discuss each one before moving to the next." He had placed a clean copy of the term sheet in the center of the table. He had said, "Term 1. The HOA executes and records an acknowledgement instrument confirming Walt Greer's ownership of the spring, the collection cistern, the pump house, and the water main on parcel C W-002-0017. The instrument is recorded against the HOA's common area parcel and against each of the 54 individual residential lot parcels. It is a public instrument in the Caldwell County deed records, not a private letter, not a settlement recital, a recorded instrument that appears in every future title search on every Clearwater Pines property." Pamela had said, "The HOA accepts term 1 in principle. We have proposed language for the acknowledgement that we'd like to discuss. The word confirms rather than acknowledges in the operative clause, a distinction that," David had said, "the operative word is acknowledges. It is not a negotiating point. The instrument confirms what the title chain already shows. Mr. Greer owns the spring and the infrastructure. The HOA is acknowledging a fact, not making a concession. The language is not open for substitution." Pamela had looked at Renee. Renee had said nothing. Pamela had made a note. David had said, "Term 2. Compensation for unauthorized use. The HOA pays Walt Greer $31,400, the accrued unauthorized use value from April 2022, the date of Mr. Greer's acquisition, through today, calculated at the benchmark annual service rate of $22,000 per year, established in the demand letters methodology. The figure reflects 17 months of unauthorized use at the benchmark rate." Renee had said, "$31,400 is not a reasonable figure. Mr. Greer has owned the property for 17 months. The water system has been operating for 14 years. He acquired a property with an operating water system, serving 54 homes. The system's existence was part of the property's context when he bought it." David had said, "The system's existence was part of the property's context, and the absence of any legal authorization for that system was also part of the property's context. Mr. Greer did not know about the system when he acquired the property because it was not disclosed in the title work. There was nothing to disclose because there was no recorded instrument. He discovered it during routine boundary work and gave notice within weeks. The compensation reflects the value of what the HOA has used from his property without authorization since he acquired it. Renee had said, "We'll pay $12,000. The table had been quiet. Walt had said, his first words of the session, "The figure is $31,400. It does not move." Renee had looked at Walt. Walt had looked at Renee with the patient attention of a man who had spent 38 years being precise about water and who had no intention of being imprecise about this. She had said, "That is a significant sum for a 17-month period." Walt had said, "It is the market rate for what your community has used from my property. The benchmark rate is supported by 3 comparables in North Georgia that David has documented in the demand. The methodology is sound. The figure is $31,400. Dale had put his hand on Renee's arm. A brief, light contact. The gesture of a man who had been on boards long enough to know when the person beside him was about to say something that would cost more than accepting the number on the table. Renee had said nothing further. Pamela had made a note. She had said, "The HOA accepts $31,400. David had said, "Term 3. The perpetual recorded water service easement. The easement grants the HOA the right to continue using the spring, the cistern, the pump house, and the water main on parcel CW-002-0017 for residential water supply to the 54 Clearwater Pines lots in perpetuity. The annual service fee is set at 9% of the HOA's annual gross assessment revenue, with a floor of $24,000 per year, regardless of assessment levels. The fee is indexed. It grows as the HOA's assessment revenue grows, which protects Mr. Greer's return as the community's property values increase. The floor protects against the HOA reducing assessments to reduce the fee obligation." Pamela had said, "The HOA's counter on the annual fee is a fixed figure, $18,000 per year, CPI adjusted every 5 years. David had said, "A fixed fee decouples the easement's value from the spring's value over time." Voss. "The spring is the reason Clearwater Pines exists. The development was built because the spring was there. The 54 homes derive their value in part from a reliable private water supply that does not depend on municipal infrastructure. That value appreciates. A fixed fee captures today's value and gives the HOA the appreciation upside. 9% of gross assessment revenue with a $24,000 floor is Mr. Greer's position." Pamela had said, 7% with a floor of $21,000. David had looked at Walt. Walt had said, 8% with a floor of $22,000. That is the floor on the fee structure. The percentage and the floor move together. I will not take 8% with a lower floor or 7% with a higher floor. Pamela had written it down. She had said, "I'll take 8% with a $22,000 floor to my client." She had turned to Renee. Renee had looked at Dale. Dale had said, 8% with a $22,000 floor is acceptable. David had said, Term 4. The HOA funds the complete replacement of the pump house equipment, the pump unit, the control panel, the instrumentation, and the electrical service, to Mr. Greer's specification. The equipment is aging. The original installation was 2008, 15 years of continuous operation, the pump unit approaching the end of its reliable service life. The replacement is designed and supervised by a licensed mechanical engineer selected by Mr. Greer. The HOA bears the full cost, estimated at $38,000 to $45,000 based on current equipment pricing for a system of this capacity. Pamela had said, "The HOA accepts Term 4 in principle. We request the right to obtain 3 contractor bids for the equipment replacement, with Mr. Greer's engineer reviewing and approving the selected bid before work begins." David had said, "Mr. Greer's engineer selects the equipment specification. The HOA obtains bids from contractors on a list Mr. Greer's engineer approves. The selected contractor is approved by Mr. Greer's engineer before work begins. The completed installation is certified by Mr. Greer's engineer before the HOA's funding obligation is considered discharged." Pamela had said, "Agreed." The final instrument had been drafted by David over the following 2 weeks, the acknowledgement and the water service easement, as 2 separate recorded documents. The acknowledgement had been 2 pages. the ownership of the spring, the cistern, the pump house, and the water main on parcel CW-002-0017, stated without qualification, recorded against all 55 parcels in the Clearwater Pines development. The water service easement had been 8 pages, the grant of perpetual access, the annual service fee at 8% of gross assessment revenue with a $22,000 floor, the equipment replacement obligation, the maintenance responsibilities, and a termination clause that mirrored the structure David had used in other Georgia water service agreements. Pamela had submitted 4 proposed revisions. David had accepted 2 and declined 2. The final form had been agreed by email on a Thursday. The $31,400 compensation had been wired to David's trust account on Friday. The signing had been the following Monday. Renee executing the acknowledgement and the easement as HOA president. Dale as witness, the notary completing the acknowledgement. Walt had signed the easement as grantor, his name on the instrument that gave 54 households their water rights back. The grant conditioned on an annual service fee, an equipment replacement, and the recorded acknowledgement of 14 years of unauthorized use that should never have been allowed to accumulate. The recording had been completed at the Caldwell County Register's office by 2 p.m. David had called Walt at 2:20. He had said, "Both instruments recorded. The acknowledgement is against all 55 parcels. The water service easement is recorded. Book 61, page 44. Walt had written the recording reference in his hydrogeological field log, the same composition notebook format he had used since his first Corps field season in 1979. The entry dated and timed, the instrument numbers noted. He had written one line below the recording reference. The spring is properly documented for the first time since Marcus Teal broke ground in 2008. He had closed the notebook and had driven to the spring. Walt had driven to the spring on the morning after the recording, a Wednesday in October, the North Georgia hardwoods on the ridge beginning to turn, the early morning cool and still. He had parked at the western access track and walked to the spring the way he always walked it, slowly, looking at the ground, the vegetation, the surface indicators that told a trained hydrologist what was happening below. He had taken his discharge measurement kit from his field pack and measured the flow at the fracture outlet, 20 minutes. The methodology the same he had used on springs across 5 states for 38 years, 85 gallons per minute. He had written it in his field notebook. The measurement dated and timed, the site conditions noted. Below the measurement, he had written, "Discharge consistent with pre-acquisition survey data. Base flow stable. Aquifer performing to characterization." He had walked east to the collection cistern, the concrete structure partially buried 20 feet from the spring pool, the inlet flow audible as the spring discharge entered the buffer volume. He had checked the hatch seal, the inlet screen, the overflow pipe, everything sound. He had walked 40 feet east to the pump house and unlocked the door with his key. The new equipment ran with the quiet efficiency of properly sized, properly installed mechanical systems. The pump unit at operating frequency, the VFD controller display showing current draw and output pressure, the flow meter on the discharge line reading the instantaneous flow. He had looked at the flow meter display, 84.7 gallons per minute, the instrumentation reading correctly, normal operation throughout. He had made the quarterly log entry, pump unit operating within design parameters, output pressure 54 pounds per square inch, flow meter 84.7 gallons per minute, cistern level normal, all instrumentation green, no maintenance action required. The pump house equipment had been replaced 3 weeks earlier. The mechanical engineer Walt had selected, supervising the installation of the new pump unit, the VFD controller, the instrumentation panel, and the updated electrical service over a 10-day construction period. The HOA had paid $41,200. Patricia Vance had certified the installation on site. The system was rated for 120 residential connections. It was serving 54. He had locked the pump house and walked east to the boundary fence, the 4-strand high tensile fence he had installed in July and August, the fence that had been the subject of Renee Cobb's letter, the fence that had been standing when the water rights notice went out, and that was still standing now, with 2 instruments recorded in the county deed index and the legal foundation finally in place. He had walked 200 feet in each direction from the water main crossing point, checking post condition and wire tension. The water main crossed under the fence at the same point where he had found it in July. the 4-inch PVC pipe at 18 inches depth, the crossing now marked with utility flags on each side per the easement instrument's requirement. The crossing location recorded in the easement's exhibit with its GPS coordinates. Anyone working near the boundary would know the main was there. He had looked east along the main's bearing, the line running into the Clearwater Pines subdivision, the rooftops of the nearest homes visible above the vegetation line. 54 homes. The morning commute sounds audible from beyond the subdivision's interior road. The normal sounds of a residential community beginning its day. The water they were using that morning was the same water they had used since August 2008. The spring had not changed. The aquifer had not changed. The fracture in the limestone shelf had not changed. The only thing that had changed was what the Caldwell County deed records showed. 2 instruments recorded the previous afternoon, Book 61, page 44, the acknowledgement and the water service easement, the legal foundation that should have existed since the day Marcus Teal broke ground on the first Clearwater Pines lot, and had not until Walt Greer found a buried pipe during fence installation on a July afternoon and called David Osai. He had walked back to the spring before returning to the farmhouse. He had sat on the limestone shelf beside the fracture outlet, the water emerging at 85 gallons per minute, crossing the shelf, gathering in the pool below. Cold, significantly colder than the October air. Deep aquifer circulation. The same water that had been moving through the limestone since before the karst formation was mapped, before the county was incorporated, before a single road was cut into the Caldwell County ridge country. He had written the final entry in the field notebook. Spring discharge confirmed at 85 gallons per minute. Water service easement recorded. Book 61, page 44. Acknowledgement recorded against all 55 Clearwater Pines parcels. Infrastructure documented, permitted, and legally authorized for the first time since 2008. System performing to design. Aquifer performing to characterization. He had written one more line. The spring was here before any of this. It will be here after. He had closed the notebook and walked back to the farmhouse across the October morning. The 1,200 acres around him, the hardwoods turning on the ridge, the farmhouse at the property's western end where it was now fully his. He had filled the kettle at the kitchen sink and set it on the stove. The water from the tap was his water, out of the limestone aquifer under parcel CW-002-0017, through the fracture in the rock shelf, through the cistern and the pump house and the distribution main, west through the farmhouse supply line to the kitchen sink. He made the coffee. He took it to the porch. The spring discharged at 85 gallons per minute in the October morning. The deed said what it said. The water did what water did.